Registering a patent for your invention in India allows you to stop others from copying or using it. It is always important to remember that patents are only enforceable in the countries in which they are registered. If you are planning on entering the Indian market to market an invention of yours there, or if you have other relevant reasons to make sure that people should not copy you in India, a patent is the way to go. In India, as in Europe, novelty is a basic requirement for patentability. Before filing a patent application, you should conduct a prior art search to ensure that the invention is actually new. Note that novelty is a global requirement and knows no barriers. The invention has to be new for the whole world to be registered in India and elsewhere. There are two different ways to secure patent protection in India: the national and the international route. This consists in filing a patent application directly with the Indian Patent Office. Note that foreign businesses must be represented by an Indian agent for this. India applies a first filing requirement. If an invention has been made in India, Indian law requires that the first patent application be filed in the country. You should either file your first patent application there or obtain permission from the Indian Patent Office to file a patent elsewhere. Once a patent application has been filed, it will be checked to ensure all formalities have been complied with and published within 18 months so that third parties can oppose the patent application. After publication, the applicant must himself request the examination of the application, during which a patent examiner will decide to accept or refuse the application. If the examiner gives a negative preliminary opinion, the applicant has 6 months from notification to reply with counter-arguments to have the patent granted. If you wish to obtain a patent for your invention in several countries at once, the Patent Cooperation Treaty is a good option. This is an international patent registration system which allows an applicant to file a single international application which has the same effect as filing a national application in the countries he chooses, including India. This system has two phases. First, the international phase involves formality check, publication, and an international preliminary examination if requested. From filing, you have 18 months to designate to which countries you wish to extend your international application, which leads to the second phase. The national phase corresponds to the application being passed on to each national patent office designated by the applicant. Each patent office then decides whether to grant the patent in its country or not. So why go through this international application system then? It seems this is just an extra layer of procedure. This system is good if you wish to file an application in many countries at once, as this saves time and attorney fees. It gives you time to decide in which countries you wish to obtain protection, up to 30 months after the filing of your original patent application. It can also prove cost-effective to have an early international preliminary examination, as it will signal you if your application is unlikely to succeed, avoiding you the costs of multiple rejected patent applications throughout the world. The whole procedure will take several years, but note that once you have obtained the patent, you will have to pay yearly maintenance fees. India requires a statement of working. Every year, you will have to file a statement in which you explain if you have used your invention in India, and if so, how. Thank you for watching. We hope this video was informative to you. If you have any questions, do not hesitate to contact us through our free of charge helpline service, where we'll be glad to answer any questions you may have.